SJC-13792, Commonwealth versus Stefano Nicholas Sarakis, and SJC-13796, Commonwealth versus Maurice M. Smith.
Okay, Attorney Lee.
Madam Chief Justice, and may it please the court. Special ADA Chi Lee for Middlesex on behalf of the Commonwealth. With me is ADA David Snovsky. He's the attorney who crafted the argument below and argued one of the motions. This is a case about applying the plain meaning and a rule against superfluity to Section 10M to reflect the legislative intent. This court has an obligation to give the statute a reasonable construction. When this court's interpretation makes a word meaningless, this court fails to respect and fulfill legislative intent and breaks the separation of powers. Therefore, this court must give the phrase not less than 2.5 years in Section 10M the meaning. The appeals court earlier—
The meaning you suggest is that this not less than 10 or whatever the years is, not less than, what is it, 2.5? Not less than 2.5 is the minimum of the maximum. That's your interpretation of that language.
Yes, under the constraint of Rodriguez, that's the only way to give that 2.5 years a meaning. And that's what the appeals court held earlier this year in Da Silva. Although there's no amicus file any brief here, the appeals court upstairs reflect that idea for this court. What the appeals court did in Da Silva was Rodriguez did not touch on the maximum of the sentence. It responded to a reported question that 1 to 2.5 years is a legal sentence. Between the conflict between the first and the third sentencing provision, this court only held that the mandatory minimum is 1 year from Rodriguez. So the question now becomes, what do we do with the 2.5 years provision? If this court were to abide by the rule of lenity without giving any meaning to the first provision of not less than 2.5 years, this court will render a sentencing provision superfluous, which is what the Hines court did, and that's why this court rejected.
But isn't not less than 2.5 years ambiguous? If you're saying one way to give it meaning is that it's the minimum of the maximum, and the other way to give it meaning, which is, I think under our majority decision in Rossetti, is that those kind of words mean the minimum term. Isn't it ambiguous? And then the rule of lenity would kick in the favor of the defendant.
No, Your Honor, because the only way to give meaning to the first sentence is to how much meaning we can give to that 2.5 years. I understand that not less than the phrase itself is controlled by Rossetti, which goes to the minimum of a sentence. However, if this court to create a minimum maximum after Rodriguez, that allows this court to give the other part of that phrase 2.5 years a meaning. If Rodriguez actually controls every sentence for Section 10M, then the legislation could have just said 1 to 10 years. That first sentence would not make any sense or any meaning if the sentence really is 1 to 10 years, and that's not what the legislation intended. So
did the legislature amend 10M since our Rodriguez decision?
In 2020, no, Your Honors, but there was a revision to Section 10 in 2024 and 2025. That was response to the Bruin case.
Did they amend at that time anything with regard to this, what I would call ambiguous, not less than 2.5, a minimum of 1? Did they do anything about that language?
No, Your Honor. However, that legislative silence is not an approval. For example, if you
they let Rodriguez stand, which says 1 to 2.5 is a lawful sentence, correct?
Yes, that did not change the interpretation of this court.
They've passed on 10A and they've passed on the Rodriguez interpretation.
However, this court, that's what happened in Rossetti. Rossetti was a case that overturned Hines' interpretation after 15 years. And in 2018, the legislature had a criminal justice reform that changed the landscape of the length of sentences. This court, however, still overturned Hines because it was an erroneous interpretation, and that's what happened here. Rodriguez was a wrong decision. It treated the third provision as a guidance for a judge to the sentencing range, what a judge can impose. But the word impose itself shows that it is about how the DOC or the administration or the government.
Was that argument raised to the court in its composition under Rodriguez in 2019?
No, and the Commonwealth—
That argument did not come up.
That's correct, Your Honor.
So this is a new argument you're saying that you're presenting for the first time for us to consider, and that Rodriguez did not have the opportunity to consider it.
Exactly. At the time, the Commonwealth should have been more helpful to the court, which is part of the reason why the Rodriguez court was wrong. And this is why this.
Excuse me, can we just, what exactly are you saying that the Commonwealth did not argue in Rodriguez? Because I actually read the Commonwealth's brief in Rodriguez, and the last 2 pages or maybe page of the brief makes an argument that reduced, I think in that case, it was pretty fine-grained arguments, and the defendant actually argued that reduce can't mean the DOC model because you can't get to a reduction to under 1 year from a 2.5-year sentence. And the Commonwealth responded to that by saying that actually the furlough provisions could. So wasn't exactly all of this before the court in Rodriguez?
Yes and no, I apologize for not being precise. That argument that the 1 year is not a mandatory minimum was raised, but the reasoning was not raised. So all the reasoning Commonwealth presented here in this case are new. That did not.
What is exactly new? Because it was debated by the parties in Rodriguez that reduced referred to actions DOC might take, was it not?
So in that case, the Commonwealth did not cite to Section 129C and D, which is about the administration of the sentence about
By the DOC?
Sorry, by the DOC, yes, Your Honor.
Okay. So you're saying because the particular sections were not identified, although the issue was covered, this is now a new argument.
And there's more to that. For example, the Commonwealth at the time did not focus on the word impose on the 3rd provision. And that word impose, we've guided this court to the plain meaning of the 3rd provision. It's about how to administer a sentence after a sentence is imposed. And if you look at there are other statutes.
What would be the limiting principle you're suggesting on our rule on stare decisis?
So this is not a case where the Commonwealth raised exactly the same argument. This is not a case.
But it has to be the same exact argument, not just one shade different.
Right, but even if it's the same, this court should not perpetuate judicial error. And in Rossetti, as Justice Wenham pointed out in your dissent, Rossetti overturned Hines based on the exact same argument that was raised 15 years ago to correct an error that reflects.
And the correction was that not less than shall mean a minimum term.
Yes, Your Honor.
And now you're saying not less than shall mean a minimum of the maximum term.
So there's really 2 points.
So really you're asking us to not overturn Rodriguez, but to revisit the clear language in Rossetti.
So if this court were to harmonize the first issue, which is what to do with the 1 to 2.5 years sentencing range after Rodriguez, the way is to treat this case as an exception, because the not less than language is a unique creature because of Rodriguez.
Didn't Rossetti say that 10M is just a different statute and we can't, we have to take it out from the scheme because it's contradictory on its face?
Yes, Your Honor, and that's why this court rejected the defense argument with reliance on Rossetti. So the point really is if
Rodriguez.
Yes, Your Honor, and the point is.
So in terms of not necessarily, I guess if you're announcing that we should announce a new rule, is there any set of circumstances under 10M where it would be lawful to impose a maximum sentence below 2.5 years?
No. If this court were to overturn Rodriguez completely, the mandatory minimum should be 2.5 years. So a legal sentence has to be minimum of 2.5 years and the maximum not more than 10 years. If this court to overturn Rodriguez. And if this court look at chapter 269, section 50, 51, 53, and 26D, these statutes have the same minimum as the reduction sentence. If the reduction language truly means a mandatory minimum, why would the legislature repeat that same language in this many statutes?
So your position, we do away with Rodriguez in a proper statute is 2.5 to something to 10.
After Rodriguez.
With a minimum mandatory of 2.5.
If this court were to overturn
Correct?
Rodriguez moving forward, yes, Your Honor.
Okay. What do we do with the 1 year language in Rodriguez in the statute?
Moving forward, if this court to overturn Rodriguez, that 1 year tells the administration you cannot reduce the sentence less than 1 year, whether the minimum or the maximum. And that's what,
But if 2.5 years is the mandatory minimum, how can anybody reduce it to 1 year? If it's a mandatory minimum, even DOC doesn't have that authority, does it?
no, Your Honor.
So what does the 1 year mean then?
Well, it could mean, for example, the FID card holders, they can be sentenced to any range to state prison. And if that sentence is less than, it's above 1 year, whether the minimum or maximum, that sentence can be reduced to less than, cannot be reduced less than 1 year. That will still apply. And that's another
Wait,
argument.
say that, I'm sorry, can you say that argument again? Sorry.
Yes, Your Honor. So in your question, the interpretation will work. The 1 year reduction will apply to FID card holders because they can
Oh, but the second sentence then becomes a problem because the FID card holders are not subject to any minimum in the statute.
Yes, but point is, if the
You're
judge,
resolving one ambiguity by bumping up into a direct express no minimums for FID holders.
no, Your Honor, my example is when a defendant is sentenced to state prison, which is possible under the statute. If that happens, for example, if the judge sentenced a defendant who has the FID card 6 months to 1 year and a half, that maximum cannot be reduced to 1 year. That person has to serve 1 year before he can be legally discharged from the DOC custody. And that's one.
But you're saying that the third sentence, which sets forth a minimum of 1 year, applies to those FID holders, which the second sentence says they are not subject to any minimum.
Yes, but until they can be sentenced to a certain range. So the person has to serve 1 year. That would apply to both minimum and maximum of a sentence
Okay,
imposed.
stop there. You said he has to serve 1 year.
Yes, Your Honor.
Isn't that a minimum mandatory?
No, a mandatory minimum is a range for the judge to impose. What the defendant actually served is a different question for the DOC administration. And then I think that's what went wrong in Rodriguez, because the focus of mandatory minimum was all focused on the judge's range. However, the third provision is about the DOC's power.
I think you're getting really greedy. You might win on issue number 1, but issue number 2 seems like a non-starter for you.
The problem with the second issue is this court only believed that it was a standalone provision, but that's not. That provision will apply to Section 7, which is what Lightfoot was about, or the four statutes that I mentioned earlier. And if you look at Chapter 265, Section 15A and B. 15A is ABW over 16 subsequent. That case has a minimum of 2 years and a reduction of 2 years. And 15B has a reduction of 1 year, minimum of 2. That shows there's a difference between how much the legislature really want a defendant to serve when there's an ABDW 2 and 2 and ADDW 2 and 1. The legislature has shown its intent of what the third provision really is about in other statutes. And if you look at 265, Section 50, 51, 53, and 26D, as I mentioned earlier, that's a case where they have the same range. That would make the third provision completely meaningless if the minimum is already 1 year. And if you look at 15A and 50B, or 18 and 19 of Chapter 65, those statutes also had an inserted language of until X number of years of state sentence have been served. The legislature have been other statutes tell this court what the third provision reduction is really about. It's about a defendant has to serve that time before the sentence.
Don't we usually, to the contrary, if the legislature uses language in one place but then doesn't use it in this statute, don't we usually attribute some significance? They could have written a statute here saying the defendant must serve such and such, et cetera, but they didn't. They said shall not be reduced.
I agree with that. However, if you look at the totality of the third provision, the only difference is really that phrase until an X number of sentence is served. And there's no other way to really treat the third provision, because the conclusion Rodriguez court did was, we don't know what to do with first and the third provision, so the rule of lenity applies. However, if you look at all other statutes, you look at the administration statutes from the DOC, it tells this court the third provision is about how the DOC should administer a sentence. No further questions. I'll rest my brief.
Thank you. Okay, Attorney St. Lawrence.
Good morning. May it please the court. Timothy St. Lawrence for Stefano Sikarakis, who's watching via the live stream. I have a lot to say about the statute, but if I could just briefly make one important point, and that's that even if this court decides that the NM sentences in this case were illegal, the court should nonetheless affirm those sentences under Commonwealth versus Ellsworth, interests of justice and finality, where Mr. Sikarakis has fully served those sentences and where the judge at the plea colloquy offered to defer sentencing to allow the Commonwealth to litigate this before sentencing. So for those reasons, we would ask for that relief. Turning to the statute itself and the first question, the Commonwealth says that there's no other way to give the 2.5 meaning. We would suggest that there is another way to give it meaning, and that's that it's not a minimum maximum. It can be viewed as a maximum minimum. And we actually think that might be what the court said in Rodriguez with its language about the lower end of the sentencing range is 1 to 2.5. We think that actually makes more sense.
Do you think it's odd that the legislature would put two different minimum mandatories? I mean, you have the not less than, which is your argument, Rossetti, that it means if you sentence, which Rossetti says, not less than means you don't have to send someone to jail. But if you do, you have to sentence to this. So here you're attributing that language, but then in two sentences later, the legislature sets the minimum mandatory at 1 year. How does that live in the same universe?
Right, and I think that's the confusion that courts have been identifying with this statute.
Unless you call it not less than in this circumstance means it's the upper end.
Right, because the court in Rodriguez said we can't kind of make sense of these two minimum terms that we're given here. And so the rule of lenity is we're going to go with the lower end.
So it's going to be 1 to 2.5 is the sentence. Really what the legislature was doing was imposing a split sentence. It's 1 year to serve, right?
Well, they couldn't, yeah, but
They couldn't, but they did.
right. So along the line, something got lost in translation there. But
Can you explain to me where you started, which was that the 2.5 years could reasonably be read as a maximum of the minimum?
right, that a judge can set that minimum term anywhere from 1 year to 2.5 years. And that would be
That I understand, but why?
okay. Well, the reason we say that is if this court says, we have to give meaning to this, which I don't think you do, but
Usually
but if
we try.
Yes, but if I guess to put it this way is, it's not clear that this is as the Commonwealth says, a minimum maximum. It could very easily be a maximum minimum because it would keep it as a minimum term. It wouldn't convert it now to the other side of the ledger, making it a sort of maximum term. So it would do less violence, I think, to the language of not less than. There's precedent where the legislature has created so-called maximum minimums, and that's 279, Section 24. It's cited in my brief. And for certain first degree, or not first degree, but certain life sentences, the legislature has said, you're not setting a minimum above a certain number. So say 20 or 30. There's no precedent that I found for a so-called minimum maximum. The only time I saw that was Hines, and that's been overruled. And we think, it would obviously comply with the rule of lenity because it would be giving the defendant the benefit of the doubt of what this 2.5 means. And then lastly, I think it strikes a better balance between sentences for FID card holders versus non-FID card holders, because under the Commonwealth theory, two, similarly situated defendants, one with an FID, one without, one is going to be entitled to not only probation, but will be entitled to a 1-year sentence where they can receive good time. But this other person, similarly situated, let's say the same conduct, is now facing a sentence 2.5 times greater. And for the simple act of having an FID card, which...
But that's what the legislature gave us.
No, they certainly should have a benefit, and it should be the option of probation.
Well, I could turn around and say, why does somebody with 4 AR-15s have to do a year, and somebody who has a 10A, who just happens to have a 22 under receipt that was given by the 25-year-old, has to do 18 months? That doesn't seem to make a heck of a whole lot of sense either.
Right, but the judge certainly has discretion to give more than a year. A judge can give up to 10 years, and we know that's the action. The 10 years is the sentence.
Well, let me just go back to this for a second, because although you say that there may be some talk that this doesn't fit within Rossetti. Rossetti really talked about that, particularly when in the not less than, that we're talking about a minimum term for an indeterminate sentence. And so why doesn't that necessarily and comfortably fit into the analysis of De Silva that the appeals court got this right? That it harmonizes with Rossetti, that if we're going to say under Rodriguez that you have to give at least a year, but the high end of the minimum term, which is the only thing that was before the court in Rodriguez, is 2.5. So that's fixed. That's the range that you can sentence under the low end, and that in keeping with what we said in Rossetti on the low end, and what we said on Rodriguez on the low end, and what we said in Rossetti on not less than, that the minimum mandatory high end is 2.5 to 10. Why doesn't that make sense to kind of harmonize all Rossetti, Rodriguez, and even though it's not authority, but persuasive authority, De Silva?
I think it asks the 2.5, the 2.5 years to do too much work.
Well, in Judge Ham's interpretation, the 2.5 does no work.
Right, which I think there is a reasonable interpretation of Rodriguez, that you chose between two minimums, and to some extent that 2.5 is a remnant of poor draftsmanship. And
or it could be the line of demarcation, right? 1 to 2.5 fixes the range that the judge has on the low end, and 2.5 to 10 fixes the range that the judge has on the high end.
Right. I just don't think there's enough to say that that's what the legislature intended when it made this statute.
Can I ask you a question about the scope of our holding in Rodriguez? It seems to me very clear from that decision that the court was faced with a really challenging statute and was trying to give effect to all parts of it. It had in front of it a sentence that was 1 to 2.5 years, and so insofar as the first sentence imposes a minimum maximum, it met that criterion. Isn't it necessary to the court's holding in terms of construing the statute as a whole that the 2.5 to 10 does do work and does impose a minimum maximum? Because otherwise, the court in Rodriguez was purporting to give meaning to all of the language of the statute, but actually was just utterly disregarding the entire first sentence.
Well, I think it qualified, and it was doing it the best job it could to give meaning to everything in the statute. I think it was quite the job with this statute. But I think the meaning that they gave it was the maximum minimum, that the lower end of the sentencing range, meaning the minimum term, the parole eligibility term, can be anywhere from 1 to 2.5. And that's how we give it meaning.
I realized that that was the question that was presented was about the lower bound, but the court was trying to give meaning to all of those sentences of the statute, right? And so what meaning did the first sentence have in Rodriguez if it didn't do anything?
The first sentence meaning the
2.5 to 10.
2.5. I think they determined the meaning of that not less than 2.5 was that it's a minimum term, and therefore we're going to, the best meaning we can give it, you know, consistent with rule of lenity and all these competing interests, is that that's the highest minimum sentence that could be given. It's not perfect, but it's an imperfect statute.
What do you do with the language that says in the second sentence that any person with an FID card shall not be subject to any mandatory minimum sentence imposed by this paragraph? Because you're essentially saying, well, 2.5 years would become a mandatory minimum at the upper range of what could be imposed as the minimum.
No, it wouldn't be a mandatory minimum. It would be a discretionary minimum. It would be the maximum that a judge could give as a minimum term.
How do you square that with the language that that a person holding an FID card won't be subject to any mandatory minimum? Because if you're going to use imposed by the paragraph, if you're going to use the 2.5 as a minimum, doesn't it run afoul of that part of it?
I think that they're treated differently. So the non-FID card holder could get 2.5, but it wouldn't be in any way mandated that they get. They could get 1 to 1 in a day, and they would actually serve. The FID card holder would serve less potentially, because they're not subject to the mandatory minimum DOC restrictions.
So you would say that the 2.5 gets transformed from a mandatory minimum to a discretionary minimum.
The 2.5 was never a mandatory minimum. It was a minimum term, and it gets it stays a minimum term, but it becomes the maximum minimum term. Is our position, and that keeps it on that side of the ledger.
Okay, thank you.
Thank you.
Attorney Durden.
May it please the court. Keith Durden, I represent Mr. Maurice Smith in this matter. And likewise with Mr. Smith, I would ask the court, in deciding this case, regardless of which way it goes, either in favor of the defendant or the Commonwealth, to take in consideration that the plea deal that was entered into was negotiated, and there is in the interest of justice, I would ask the court that it give some finality to that sentence and allow Mr.
Has Mr. Smith served the sentence?
He's practically served the sentence. He's almost done.
Okay.
With respect to the statute 26910M, it's our position that, as the court noted in Rodriguez, it's a very imperfect statute.
It's imperfect, but if we in Rodriguez intended to create this new range of 1 to 2.5 years, why didn't we just say so? We didn't say that.
I think that with the court, well, in the language in Rodriguez, it can be interpreted in such a way where that's essentially what the court did say. And that's
well, then what does that do? What does that do to the 10 years?
Well, I believe there's a bifurcation between the lower end of the sentence and the higher end of the sentence. And what we argue is that the lower end there of the sentence is where the mandatory or the minimum sentence should be served, whereas the higher range of the sentence, or the higher number, is one where the court has a great deal of discretion. So, theoretically, a judge could sentence someone to 1 year at least 1 year in the minimum, but the higher sentence could impose a higher sentence, 3 years, 4 years. or even more.
Well, it seemed to suggest that, okay, so in your view, this was just a sentencing decision that Judge Hahn made, that the high end was going to be a year and a day.
Yes, correct, Your Honor.
Okay. But I guess I go back to the question I asked your brother. Well, what does that do to the 2.5 years? Doesn't that render that number just superfluous?
I think certainly it can render the 2.5 years superfluous, and we accept that. However, I think that given the statute being written the way it was written, there's a great deal of difficulty in interpreting it.
So you would disagree with counsel that we can give 2.5 years meaning by keeping it on the minimum end of the ledger and just saying it's the maximum of the minimum?
The court could do that.
Well, no, but
certainly.
I'm asking
But
for your
yes,
view.
If the court were to do that, I think the difficulty with doing that is the way these statutes, well, I guess presumably the court could, well, yes, it would give meaning to.
Right, because it would still be a minimum term.
Right. But
would still define the upper end of the minimum term, and so would have some meaning. Not less than, as Rossetti says, is a minimum term. 2.5 is what comes after not less than. And then we also have this weird third sentence, which is 1. So 1 to 2.5 is the range for the minimum term. That gives every phrase in the statute a meaning.
Yes, Your Honor, I agree with that. I believe that, I would argue that a judge could impose for the minimum range of the sentence, a 2.5-year sentence. Of that sentence, 1 year would be mandatory.
Right.
And obviously, the higher range of the sentence could be whatever the court feels is appropriate. And as Your Honors know, the problem stems from the ambiguity in the statute. We have 3 classes of individuals, people who are convicted of the crime overall, and then bifurcates them into 2 further distinctions, those with FID cards and non-FID cards. I would argue that if the court were to allow the construction or interpretation of the statute that we're proposing, it would give meaning to the statute, the entire statute, and give a judge discretion in dealing with anyone who falls into any one of those 3 categories. There's also a public policy argument that could be made in defense of the position that we're proposing.
And what would that be?
Well, minimum mandatory sentences obviously reduces the discretion that judges have in deciding these cases, or crafting a sentence that they feel is appropriate given a person's background and given their history. By giving trial judges more discretion, and I believe the statute as interpreted in Rodriguez, which I believe is a good compromise, it gives those judges those tools that they can use.
But they would still have that even under that construction, because you would still have on the low end, you have to give at least a year, but on the high end, you have anywhere up to, you have up to 2.5 years, right?
Right. I guess my argument would be that if we increase the minimum mandatory sentence, that would be further tying trial judges' hands in crafting a sentence. It's understandable where a judge can be faced with a situation where there's a defendant where it's appropriate to give them, as in our case, a 1 year to 1 year and a day. So we would argue that there's the statute being ambiguous and Rodriguez being a good compromise of all the terms inside the statute, that the court should allow or adopt the construction or the interpretation of the statute that we're proposing. Thank you.